Hello everyone. Well, I'm off at a conference, but in lieu of our class today, I've made a video lecture for you. We're going to cover some of the free speech material that we ordinarily would have covered in class. We're going to start in this video with a series of cases that deal with free speech and dissenting views, and particularly how those dissenting views come into conflict with the common good, and how government sometimes tries to regulate them to protect the public interest. I'd like to start with some sort of broad view considerations about the setting here. Prior to the 1930s, the Supreme Court did very little to place any kind of limits on government's ability to interfere with speech, particularly that of dissenting views. That began to change for a couple of reasons. One was because prior to 1925, the Free Speech Clause of the First Amendment, as well as the rest of the Bill of Rights, had not been incorporated to apply to the states. So those provisions only placed limitations on the federal government and not the states. And you guys already know a little bit about incorporation. We've discussed it before. You've read Duncan versus Louisiana and some of the other cases that dealt with various approaches. But that whole long process of incorporating the provisions of the Bill of Rights to apply to the states really starts in 1925 with a case called Gitlow versus New York. So it's really not until then that there's any prospect for the court to place any limits on what states do with respect to restricting speech or engaging in censorship. The other factor was, of course, that the court simply didn't take much of an interest in protecting these kinds of civil liberties prior to the 1920s, really. Now, we get our first big contests over legal restrictions on free speech in the early 20th century, especially in the context of World War I, over which there was a great deal of political dissent. We talked about earlier in the semester the fact that the Civil War had presented some cases of very serious political dissent and very serious efforts on the part of the Lincoln administration to tamp down efforts to interfere with the war effort and so forth. But those decisions were made politically. The constitutional determinations about the extent of free speech and the appropriate level of government limitations on it in time of war were largely made through the political process, a contest between the president and Congress. In fact, when the court made an effort at that time through Chief Justice Taney's ex parte Merriman decision to try to put a limit on what the Lincoln administration can do, the administration simply ignored it. In World War I, the court does not ignore these considerations, and a couple of very serious conflicts emerge from the political environment. One was in a case called Schenck versus United States in 1919. This is probably the most famous of these cases because it gave birth to a doctrine that guided the Supreme Court's determinations about when government could punish speech, particularly political speech, speech aimed at commenting on or altering public policy. In this case, Schenck was a part of the Socialist Party in the United States and had been responsible for distributing leaflets that, among other things, denounced the draft, which was a fairly newfangled thing in American public policy, but it denounced the draft as a violation of the 13th Amendment, as a form of involuntary servitude and slavery without conviction of crime, and urged people to assert their rights, which the government took to mean that Schenck was urging individuals to refuse to serve in the military subject to the draft. He was prosecuted for this, and his conviction was ultimately upheld by the court in a very famous opinion by Oliver Wendell Holmes Jr., in which Justice Holmes made clear that a position of free speech absolutism was not consistent with the First Amendment. In fact, he used a very famous analogy saying that no one would contend that that the First Amendment would protect a person falsely shouting fire in a crowded theater because of the danger that would pose to others. From this, he derives the famous test, the clear and present danger test. Let me read you his formulation very briefly, which you'd find on page 420 of your textbook. Justice Holmes made this statement, that the question in every case is whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. It is a question of proximity and degree. When a nation is at war, many things that might be said in time of peace are such a hindrance to its efforts that their utterance will not be endured so long as men fight, and that no court could regard them as protected by any constitutional right. This decision was followed very soon. We're on the Schenck decision here. Which gives us the clear and present danger test. This was followed very soon by another famous case, which involved Eugene v. Debs, who had twice been a candidate for president, spent some time in prison already. But Debs was a very famous socialist activist, and he was prosecuted by the government as well for his efforts to obstruct the war effort by opposing it through his public activism and very fiery speeches. Debs' conviction was upheld just 3 weeks later after Schenck, again in a decision by Justice Holmes. And this time, Holmes made a very interesting statement and seemed to have in some ways tempered the clear and present danger test, because he says this. He says that persons could be constitutionally convicted when the words used had as their natural tendency and reasonably probable effect to obstruct the recruiting service. So here you have what is sometimes called the bad tendency test. Sort of brigaded with clear and present danger. And of course, bad tendency, something having a bad tendency, would seem to be something of a lower bar than clear and present danger. Now, the next great controversy that emerges, though, involves not just socialists, but a very important religious group in our history, Jehovah's Witnesses. In the 1920s, 30s, and 40s, Jehovah's Witnesses are tied up in a series of constitutional litigation in which state policy primarily sought to place limits on their ability to proselytize and their ability to withhold their participation in certain public activities. Most importantly, in the salute of the flag in school classrooms, which some states had laws requiring of school students, and their refusal to say the Pledge of Allegiance. Of course, this was based on a theological premise for them that suggested that doing so would constitute giving one's allegiance to a political order that ought really only to belong to God. Now, Jehovah's Witnesses began to win some recognition of their rights to exemptions from these kinds of laws, particularly with respect to proselytizing in the 1930s. The case of Lovell versus Griffin, 1938, was an important instance of this, where the court actually strikes down a licensing law that was required for leafleting. Of course, Jehovah's Witnesses are most famous for going door to door and handing out leaflets and proselytizing in that fashion. So in this particular case, a city government, through its city manager, passed an ordinance that said that anyone wishing to pass out leaflets or literature of any kind would have to obtain a license from the city to do so. Of course, with the intention of limiting the ability of groups like the Jehovah's Witnesses, particularly Jehovah's Witnesses, to be able to go door to door and pass out this literature. The court strikes that down largely on the ground of free press. It's worth looking at some of the language that the court uses in that instance, and you can find some of this in your textbook, particularly on pages 540 and 541. You see Chief Justice Hughes, writing for a unanimous court, says in this case that whatever the motive which induced its adoption, its character is such that it strikes at the very foundation of freedom of the press by subjecting it to license and censorship. The struggle for the freedom of the press was primarily directed against the power of the licensor. So the notion that one could require, that a government could require that anyone who wanted to distribute literature or engage in essentially the activity of publication and dissemination of information would have to seek a license or an approval from government was inimical to the concept of free press as the court saw it. A very important unanimous decision there. This was followed by a series of cases involving the flag salute, which probably got a lot more attention and turned out to be much more important in terms of American constitutional development. Initially in 1940, in the case of Minersville versus Gobitis, the court upholds a mandatory flag salute law. It becomes very controversial, but Gobitis was the parent of a number of public school students and was a Jehovah's Witness. And when his children refused to salute the flag in the school classroom according to the state's regulations, he was prosecuted for this. When the court upheld that statute on the ground that the state had a legitimate interest in promoting patriotism and civic commitment among its students through the public schools, the result was widespread discrimination and violence in many cases against Jehovah's Witnesses. It's a very unfortunate chapter in our history, but people turned out to be extraordinarily intolerant toward the Jehovah's Witnesses, and they suffered greatly. This, of course, was followed. If you think about the context we're dealing with here, of course, Great Britain goes to war with Germany right in the midst of all this. And by 1942, the image of Nazis, particularly of the Hitler Youth in German schools, saluting portraits of Hitler and saluting the Nazi flag, saluting the swastika, had created a certain impression on the public mind, and particularly on national policymakers who wished to distinguish ourselves as a liberal political order committed to individual rights from the kind of authoritarian fascism that we were seeing in Europe, particularly as it manifested itself in nationalist policies and expressions of national commitment. And in fact, what really impresses a person is whenever you look at the pictures. This is, of course, a picture of the flag salute being carried out in an American schoolroom. As you can see, unlike the modern practice of placing one's hand over one's heart, which doesn't become the predominant American practice until after World War II, the students are saluting with a hand up. Originally, the salute would have been something like this, which should be very familiar to us all. As an initial gesture, you would see in the picture that many of the students have their hand palm upward, which was supposed to distinguish the American demonstration of commitment to our flag from the Nazi and nationalist demonstrations in Europe. But that's really not enough. Congress, as well as the executive branch, by 1942 had recognized that this was a significant interference with the liberty of individuals to freely exercise their religion. So in 1942, Congress actually passes a law that insists that citizens showed full, as they say in the law, full respect to the flag merely by standing at attention during the recitation of the pledge. So in other words, no requirement that the students engage in a salute, raise their hand, and no requirement that those students, or anyone else for that matter, be required to recite anything in the way of a pledge. So merely standing up respectfully was adequate to show one's full respect. So there was no expression of allegiance and no expression of anything of that kind. The Roosevelt Justice Department actually insisted that this preempted state and local laws that required flag salutes and things of that kind. So one could argue that by 1942, federal law, at least if you think the federal government had the authority to do this, had actually displaced state requirements for flag salutes and for the recitation of the Pledge of Allegiance in school classrooms. Nonetheless, states continued to enforce its laws, and the most famous case in this line comes up in 1943 in the West Virginia Board of Education versus Barnett. This involved a West Virginia law that required students to salute the flag, and in this case, the court overturns Mitersville versus Gobitis quite explicitly. The vote in the case was 6-3. Justice Jackson, who, by the way, was probably one of the court's best writers, Justice Jackson writes the majority of opinion, and one that's often cited. And it's worth looking at a couple of passages from his opinion to see the rationale that he employs here. And you can see at work in Justice Jackson's opinion a certain reaction against authoritarian and nationalist movements in Europe. And just a few lines from what he has to say. He says, the right of a state to regulate, for example, a public utility may well include, so far as the due process test is concerned, power to impose all the restrictions which a legislature may have a rational basis for adopting. So ordinarily, when the state can pursue a legitimate objective, it can adopt any kind of limitations or regulations of conduct that are necessary to pursue that end, including criminally punishing individuals for refusing to comply with state policy. And that ordinarily is a determination to be made by the state, subject only to a showing that it has some rational relation to the end. But Justice Jackson makes clear that whenever speech is implicated, that burden becomes much higher. So he says, but freedoms of speech and of press, of assembly, and of worship may not be infringed on such slender grounds. They are susceptible of restriction only to prevent grave and immediate danger to interests which the state may lawfully protect. So this is something akin to though the court had not at this point yet developed the strict scrutiny standard, you all already know that that will emerge in Korematsu versus United States in very short order. He does articulate something like it. There has to be a grave and immediate danger to interests which the state may lawfully protect. So what about the state's interest in creating a patriotic sentiment in its children? Justice Jackson addresses this. He says, struggles to coerce uniformity of sentiment in support of some end thought essential to their time and country have been waged by many good as well as evil men. Nationalism is a relatively recent phenomenon, but at other times and places the ends have been racial or territorial security, support of a dynasty or regime, and particular plans for saving souls. As first and moderate methods to attain unity have failed, those bent on its accomplishment must resort to an ever-increasing severity. As governmental pressure toward unity becomes greater, so strife becomes more bitter as to whose unity it shall be. Probably no deeper division of our people could proceed from any provocation than from finding it necessary to choose what doctrine and whose program public educational officials shall compel youth to unite in embracing. Ultimate futility of such attempts to compel coherence is the lesson of every such effort, from the Roman drive to stamp out Christianity as a disturber of its pagan unity, the Inquisition as a means to religious and dynastic unity, the Siberian exiles as a means to Russian unity, down to the fast-failing efforts of our present totalitarian enemies. Those who begin coercive elimination of dissent soon find themselves exterminating dissenters. Compulsory unification of opinion achieves only the unanimity of the graveyard. Very eloquent denunciation of this kind of effort, but the kind of denunciation that one would usually not find so much in a Supreme Court opinion is in a legislative debate or a public appeal, one that one could expect from the lips of a Eugene V. Debs, maybe. And indeed, three members of the court dissent, most importantly Justice Frankfurter, who points out, he says, that as far as he can tell, the conception underlying the 14th Amendment of the court's role in enforcing rights does not permit the court to overturn reasonable regulations of conduct, even when those place some burden on constitutional rights. He says that these rights leave open the possibility that states can regulate their exercise in the public interest. He says, I cannot bring my mind to believe that the liberty secured by the Due Process Clause gives this court authority to deny the state of West Virginia the attainment of that which we all recognize as a legitimate legislative end, namely the promotion of good citizenship by employment of the means here chosen. He goes on later to say that the states that require such a school exercise do not have to justify it as the only means for promoting good citizenship in children. You know, American government classes and constitutional law would be a good start too. But merely as one of the diverse means for accomplishing a worthy end. We may deem it a foolish measure, but the point is that this court is not the organ of government to resolve doubts as to whether it will fulfill its purpose. Only if there be no doubt that any reasonable mind could entertain, can we deny to the states the right to resolve doubts their way and not ours. So Justice Frankfurter here, insisting on deference to legislative judgment whenever it comes to what a reasonable means to legitimate state ends would be, and insisting that the court should hesitate to overturn those state efforts. Of course, you'll recognize in that kind of rationale of deference the fact that Justice Frankfurter is adhering to a notion of deference, in this case applied to constitutional rights, that had very much been the clarion call of the New Deal in objecting against progressive era judicial activism in protection of property and economic rights. And Justice Frankfurter wants to make this kind of deference general and defer to the political process in a broad way, both with respect to government powers and federalism, but also with respect to the reasonable regulation of rights. His colleagues, following the rationale that, of course, been mapped out in footnote 4, which you've seen, insist that no, whenever it comes to constitutional rights, especially those in the Bill of Rights, the court has a role in imposing a more exacting standard. So West Virginia Board of Education versus Barnett set a very high bar for coerced speech. Anytime the government sought to coerce individuals to make an affirmation of an idea, they were going to have to pass an extraordinarily high bar. In fact, one could actually question after West Virginia Board of Education whether government can really criminally coerce individuals to affirm ideas. Of course, there are aspects or instances where constitutionally individuals are required to affirm things. The simplest example is the constitutional oath of office. Every member of a legislative chamber in a state is required by the U.S. Constitution to swear to protect and uphold the Constitution of the United States. The President of the United States is required to take an oath of office. In fact, every federal office holder, members who enter the United States military are asked to affirm that they will bear true faith and allegiance to the same, meaning to the United States and to the Constitution. So there are instances where we do require individuals to do this. The important thing is those individuals are not being coerced to do it as a criminal matter simply because they are citizens, but because they want to enjoy the privilege of office holding or serve in the military. So there are thresholds to those things, and including when one takes the oath of citizenship. If you were born in the United States or a natural-born citizen, you, of course, never had to take an oath of allegiance to the United States in order to do that. if you want to become a citizen, that of course is required of individuals who become citizens. So there are instances where government can ask as a prerequisite to enjoying some privilege of citizenship that individuals affirm certain ideas. But the court here insists that government cannot reach out and simply sort of take hold of the country's children or of others and force them to affirm even their allegiance to the country. Now, of course, coerced speech is very, very difficult to justify. It's somewhat easier to justify prohibitions on speech. It's easier to show that certain individuals could be prevented from saying certain things, that prohibitions or proscriptions on speech could be passed, as opposed to prescriptions or affirmations. Now, the court embarked on a fairly vigorous protection of dissenters in the wake of West Virginia Board of Education versus Barnett. The exception, for a time at least, was communists. Whenever we had such a high level of anti-communism, especially in the midst of the Cold War, the clear and present danger test in that context turned out to be a pretty low bar. And it was, excuse me, it turned out to be a relatively low bar whenever it came to the protection of communists. The so-called bad tendency test had already suggested this in the Debs case way back at the same time that the clear and present danger test was established in Schenck. Of course, we should note here too that anti-communists were not just paranoid witch hunters. Even if Senator Joseph McCarthy was a pretty despicable individual and his behavior was fairly inexcusable, it is important to note that the efforts of anti-communists were not simply paranoia. There really were a substantial number of individuals within the federal government and in different sectors of the American economy and industry who were in fact working for the KGB and for Russian intelligence. We've been able to find that out now because KGB files have been slowly unearthed and opened up to scrutiny by scholars and historians who have established that in fact many of the individuals who were accused by, for example, the House Un-American Activities Committee, of which McCarthy was chair, and many of those individuals which we actually prosecuted for espionage, were in fact guilty of it. Some of them rather naively, but they were in fact passing information to the KGB, and that was a very serious threat. Espionage was a very serious threat during the Cold War, and something that we shouldn't discount now. But the court did eventually raise the bar for punishing offensive speech, including that speech which was subversive of the country, that is, speech that was aimed at promoting the most radical kinds of dissent, disloyalty, disobedience to law. The most famous case in this regard comes in 1969 in Brandenburg versus Ohio, and gives us what is still the binding test with respect to punishing political speech. Brandenburg I think it was Clarence Brandenburg, was the leader of the Ohio Ku Klux Klan. It's involved a Klan case. There are other similar cases involving neo-Nazis, communists, and others. In the Brandenburg case, there had been a Klan rally to which Brandenburg and other members of the Klan had actually invited local media, television news media, who showed up for this thing. Of course, you can imagine the setting, a sort of a rally out in the woods, the burning cross, grown men in bed sheets, all that sort of thing. In the midst of all this, on a number of occasions, Brandenburg and his compatriots posed for the camera, and you hear rants of various kinds. And in the most famous of these, Brandenburg says, we're not a revengent organization, but if our Congress, our president, our Supreme Court continues to suppress the white Caucasian race, there might have to be some revengeance taken. I'm sure that Brandenburg was not aware of the fact that vengeance and revenge are both words, but that revengeance really isn't. Brandenburg was prosecuted under the Ohio criminal syndicalism statute. This statute made it a crime. Essentially to teach the duty or necessity of overthrowing government. And the state of Ohio claimed that the statement to the effect that the Klan planned to take revengeance on the federal government indicated that they intended to overthrow the government. That's an understandable supposition, but at the same time, somewhat far-fetched. It's not entirely clear how a few dozen individuals in rural Ohio with shotguns and hunting rifles were going to overthrow the federal government, and it really sounds like more of a case of somebody shooting their mouth off. But the court takes this case and announces a new standard, which becomes the primary test for government efforts to punish speech. This is what's often called the incitement test, because it's a two-part test that says anytime the government wishes to punish someone for teaching the necessity of violence or advocating for lawless behavior, the government has to show that that speech constitutes incitement to imminent lawless action and that it is likely to produce that action. So two very important components. And here the court says that really Brandenburg's speech fails both. Vague threats to the effect that there'll be revengeance on the government doesn't really constitute incitement to imminent lawless action. Imminent's one of the key words there. The notion is that it can't be something prospective or hypothetical, but has to be something relatively immediate, something to happen in the near future, and something concrete. So if in fact Brandenburg had cooked up plans for a revolt or an overthrow of some kind, and was giving a speech to urge his followers to carry out that plan, that might be incitement to imminent lawless action. One could imagine this in a modern context of for example, someone teaching the necessity of jihad against the West, and there would be a difference, according to this standard, between an individual merely teaching religious doctrines that might lead people, might have a tendency to lead people eventually to violent action, and a teaching that constituted this kind of incitement to imminent lawless action. One could imagine the head of a terrorist cell who is sort of whipping up his followers to carry out a concrete plan that has been laid. That would really be incitement to imminent lawless action. Merely teaching religious doctrines that might lead to that kind of behavior at some point would not be according to the court's rationale. And of course, even if one establishes that there's incitement to imminent lawless action, that action has to be likely to take place. This is often where many prosecutions get hung up, because the truth is that a great many people out there can say a great many crazy things, and no one may listen to them. So if you just have a madman on the street corner insisting to the passers-by that they have to help him overthrow the government, that might be incitement to imminent lawless action, but that anyone's likely to listen to him is less plausible. The next major, I have to find my marker here. I'm done with it. We'll get a different color. So I've put it in my pocket. There it is. So we've dealt with this issue of coerced speech in Barnett. We deal with the issue of punishing political speech or punishing political dissent in Brandenburg. And we see that both of those establish very high bars. The remaining standard that the court establishes in this period comes with respect to the issue of prior restraints, and especially with respect to government secrets, that is, government efforts to prevent the press from releasing what the government sees as damaging information. And of course, this comes up in the case of New York Times versus United States, 1971. New York Times case is, of course, probably the most famous of the free press cases. Certainly stands next to New York Times versus Sullivan, which erected a very high bar to libel suits pressed by public personalities, particularly office holders. But New York Times versus United States dealt with the prior restraint of publication. Of course, the issue here is the Pentagon Papers, which very famously had been furnished to the New York Times by Daniel Ellsberg, who was an employee at the Department of Defense. The Pentagon Papers themselves were a long document consisting of many volumes that constituted a history of the Vietnam War. It had been commissioned by Secretary of Defense McNamara at one point during his tenure and was held there in the Department of Defense. And this document contained what was seen to be a great many embarrassing details about the way in which the United States had gotten itself into the Vietnam War, the way it had conducted itself during that war, and it was considered that it would be embarrassing to past presidential administrations in particular, and that it would harm the United States foreign policy or our standing with the rest of the world. When Ellsberg gives us the New York Times holds on to them for some period of time, a number of months, during which they were looking over the document and deciding what to do with it. During this time, they didn't notify the government that they had possession of the documents, but once they determined to publish them, they announced that intention and began publishing a series of excerpts from them in the newspaper. After they had done this for a few days, the Nixon administration went to the Federal District Court in New York and asked for an injunction. This would be a court order to command someone to stop doing something. And they wanted an injunction for the New York Times to cease publishing. And the Times, of course, appeals. The case gets appealed to the Court of Appeals. In the meantime, and this happens within just the course of a couple of weeks, the Washington Post has gotten a hold of the document and has begun publishing it as well, at which time the Nixon administration seeks an injunction from the Federal District Court in Washington, D.C. In the midst of all this litigation, the Supreme Court promptly announces that it desires to weigh in on the subject, and I'm trying to recall the date off the top of my head. I don't. Let me look very quickly here. On June 25th, 1971, the Supreme Court notified the parties that both of the cases, both the New York Times case and the Washington Post case, would be reviewed by the court, and they insisted that briefs and oral argument would be due the following day. So attorneys, both for the newspapers and for the Nixon administration, stayed up all night producing what they could in the way of briefs. Of course, they didn't really have full information. They showed up with these written briefs the next day, gave oral argument shortly thereafter the same day, and then the court issued an opinion a mere 4 days later. So this is a really unprecedented and unique in the short time frame with which the court dealt with this case. Of course, the question in the case was whether federal courts should issue injunctions to cease publication. That is, whether they should engage in prior restraint by way of judicial orders. And the court issues a per curiam opinion in the case, which states what is taken to be the primary holding, which is that any prior restraint of publication has to pass an extraordinarily high bar. In fact, one of the separate opinions in the case from Justice Brennan suggests a standard for this, though Justice Brennan's opinion is not binding. But Brennan's opinion suggests that only governmental allegation and proof that publication must inevitably, directly, and immediately cause the occurrence of an event kindred to imperiling the safety of a transport already at sea can support even the issuance of an interim restraining order. So before a court could take this kind of action, Justice Brennan wants to suggest, And often Justice Brennan's opinion is taken to sort of be implied somehow in the per curiam opinion, though it's really not officially part of it, that you would have to have something akin to threatening a military transport at sea, or publishing troop movements that may imperil the lives of American service members, and that has to be direct and immediate. It can't even be prospective or in the future or something that the government could adjust to or deal with. So that's a very, very high standard. It suggests that the courts are almost never going to allow prior restraint of publication, though it does leave open the possibility. Now, accompanying this per curiam opinion, which is the official opinion of the court, are a host of separate opinions in the case. And there are a few of these worth talking about. And the justices tend to fall into groups whenever they issue these opinions. So the groups go something like this. You have Justices Black and Douglas, who are the only two free speech absolutists on the court. And they really contend that prior restraint is never appropriate. Prior restraint can never be constitutionally justified. They leave open the question whether an individual could be punished after the fact for having done something that imperiled national security, but their opinions seem to leave no room for any kind of prior restraint whatsoever. Justice Brennan comes close to that with his example of imperiling a military transport, but Justice Brennan diverges from them in admitting that there may be some circumstances. Yet for Justice Brennan in this case, the government's failed to show that. They failed to demonstrate this kind of direct and immediate need to protect the lives of Americans that would ordinarily justify this kind of prior restraint. So for him, it fails. The next pair of justices, Justices White and Stewart, both seem to suggest that really the appropriate institution for dealing with this kind of threat is the executive branch. That the president's asking the courts to do something the executive branch is really responsible for. They say if there's an imminent threat to national security, isn't this something that the executive should handle? Now, they're not very concrete about what they mean by that. I mean, I don't know if they're suggesting that the executive should physically go in to the New York Times and Washington Post and take the Pentagon Papers back, or physically shut down the presses. It's not altogether clear what they mean. But in any case, they say, look, there's just simply nothing that courts can do. So they're both focused on the notion that courts really don't have a role here. So in that case, Justices White and Stewart join the majority of the court, join the opinion of the court on the grounds that while there may be a way of preventing publication, that means is not a judicial means. It would be a means of executive action. So they don't really, so while they join the outcome of the case, that is that the case ought to be dismissed, it's on much different grounds than Justices Black and Douglas and Brennan, who think that prior restraint can almost never be justified. Justice Marshall sort of stands alone in this case in some ways. And he suggests that really the answer here, he says, look, Congress has laws that allow subsequent prosecution of those who divulge government secrets and things of that kind, those who break the law or leak intelligence. And he says if there's information of that kind involved in these cases, then I'm sure that the executive branch could bring a suit bring a criminal suit after the fact for those involved. Now he leaves open the possibility that Congress could in fact pass a law that would authorize courts to issue injunctions in cases where the executive thought it was necessary. He says Congress has declined to pass a law of that kind, and in the absence of that kind of legislation, the judiciary simply doesn't have this kind of discretion. So he really pitches to Congress here and says that this is really Congress's job to decide when the president should or shouldn't have this kind of authority. And until Congress has made some provision, the court really can't do much about it. The last group of justices, which is really a trio, is formed by Chief Justice Berger, Justice Harlan, and Justice Blackmun. And all of them contend essentially the same solution. They all say, look, it may be the case that there's a very, very high bar for prior restraint, and there ought to be. Whether the government has cleared that bar is an open question here. We simply don't have enough information, and the only way to get adequate information would be to hold a full trial to air all this. And so they all urge that what ought to happen in the case, instead of dismissing the case and vacating the injunctions and so forth, that they ought to temporarily enjoin publication, and in the meantime have a trial in the district court to determine whether it's appropriate to issue those injunctions on a permanent basis. Now, the difference between these three and some of the other justices is that Justices Black and Douglas and Brennan all contend, particularly Justice Brennan contends, that to delay a decision, to delay publication, even to conduct trials, is itself a violation of the First Amendment. That is, to prevent publication even for a temporary period of time would be a serious infringement on free press. Whereas the three dissenters here insist that, delaying publication, at least temporarily, even for expedited trials, would give us enough information to make an informed decision. Having briefing, having the parties brief the case in the course of 24 hours and then making our decision in 4 days simply is not enough time to make this kind of judgment. This is a complex decision, and we need to hear more from the executive about the justifications involved. So really, as you can see, I think what I want you to walk away from this case understanding is that while New York Times versus United States often gets cited sort of out in public, it gets cited, particularly in the newspapers and the press, as a sort of absolutist decision to the effect that government can never enjoin publication of government secrets. That's not really what the case comes out and says. It really doesn't answer the question of what kinds of justifications would be adequate to make prior restraint of this kind of information legitimate. And there's quite a diversity of opinion on the court. There really is not a majority in favor of any of these positions. At most, you get 3 justices in favor of a relatively absolutist position. You get 3 justices who really want to leave it to Congress and the executive in some sense, and you get 3 justices who want the court to decide, but want the court to decide after a full and adequate trial, a fact-finding process. So the court has really never offered us a settlement of which of those approaches is really appropriate. So for example, in the recent, the WikiLeaks case, in the case of Edward Snowden, in cases like that, while it's very popular in the press to suggest that New York Times versus United States settles this question, the truth is it really doesn't. So, just as a quick review here over what we've covered, we've suggested that the court's protection of free speech in particular, and really of civil liberties generally, takes off at the beginning of the 20th century. Of course, that was already suggested by our consideration of footnote 4, and you all saw that coming. That the court initially set a relatively low bar for this with the clear and present danger test, the bad tendency test. The court also, around that same time, issued some opinions that suggested that there were other exceptions to the First Amendment, like fighting words and so forth. But the court eventually raised the bar considerably. And they raised the bar considerably for prior restraint. They raised the bar considerably for any form of coerced speech. And they raised the bar considerably for the suppression of political dissent, as the punishment of political advocacy, even when that advocacy involves breaking the law. The court wants to protect political advocacy with a very, very high level of protection. So that's where we stand. I hope this was helpful to you. We'll discuss these cases in more detail when we come back to class next Tuesday. And we'll also cover the remainder of the free speech cases that we haven't talked about yet. In particular, the campaign finance cases, the flag burning case, and the symbolic speech case in U.S. versus O'Brien. So thanks very much. I'll see you next week.